You're joking. Not another one? Hi, and welcome to Not Another HR podcast. I'm Rachel Rigg from Horsfield Menzies.
I'm Alastair Swindlehurst from Easy HR.
As ever, this is a podcast and is not legal advice, and so if you need legal advice, we suggest you go and consult a legal advisor, and everything we talk about today might be accurate of the day of filming, but might not be accurate for much longer.
You're really impressed how
I mean, employment law keeps changing.
It does at the minute.
It's
thick and fast at the minute.
It is. So Go on, what have you been up to?
What we've been up to? Oh, it's been, generally speaking, because we're start of August when we're recording this, it's just like, you can see sort of the time when everyone decamps on holiday. No one's decamped on holiday this year. It's absolutely bonkers. And a lot of it is actually about people that are declaring themselves as having an illness, but then refusing to go off on the sick at this moment in time. We've got a number of people that are who are saying they've got various serious issues, and then just going, I'll just continue to work if that's okay.
It's like, what? Huh?
Yeah.
Okay, great. So trying to unpick those riddles bit by bit.
Yes.
Yeah.
And it's definitely, I think it's definitely a fun one out there at the minute. So it's having to sit down with people and go, like, so let's just, people go, I want to go to the doctor and get a fitness a return to work. And my bum, we don't have those anymore. That ship has long sailed.
Yeah, I mean, it's one of those, isn't it, where it's so dependent on what it is that someone's saying. You know, what are the sorts of things that you're having come across? Like, is it neurodivergence? Is it stress? Is it something more physical?
It's generally more physical. And to be fair, it's serious stuff, you know what I mean? And it's the thing, you've got to take it seriously. But I think it's the bit where, and I think it's where people probably feel under the cosh. And I always think if you look at kind of, it's the secondary issue, it's the what you're having the row about. And with these people, it's definitely, I think there is generally not in like the most amazingly paid jobs. And actually one of them was in quite a really well paid job. But I think because everyone's at their limit at this moment in time, like the thought of taking time off and getting paid SSP, and as delectable as it is to get SSP from day one, and above, if you, and especially from the lower earning limit, it's just not quite the mustard.
No.
And people being forced into corners to make quite aggressive decisions, or they feel they need to make quite aggressive decisions at the minute. So again, I think it's the way that people come at the blocks at the minute. It's not can we have a conversation about how we manage this? This is a kind of like go full kind of scrappy do. It's
gone mad. I just feel like everything's more entrenched at the minute. Like things are so much further down the line when they're coming to a head. Yeah,
I was chatting to a guy that I used to do some bits with, and he's ex-ACAS, he's ex-regional director for ACAS, and he's got about sort of 10, 15 years on me. And I started in 2003 when I started doing HR, and I was walking through picket lines in my first week. We need to have a conversation on my first two jobs. It was wild.
I've seen some things.
It was. You were there. And I think there's a challenge in terms of, I think certainly for the HR community, where people have, certainly since about 2010, everything's been pretty plain sailing. Like it's never been.
Do you think that's a result of financial dip 2008, 2009? Everyone's just grateful to be in a job in 2010.
But I also think there's kind of the employment law stuff kind of worked. Everyone had found a rhythm. Nothing was too bad. Markets were generally up. It wasn't too hard to get a job. But I think your post-financial dip is a really good point, because I think we're not where we were. And it's really like, if you look at because I read, I've got the Times subscription, and they've got some really good stats that they follow, and you look at like employment and stuff like that, and like although unemployment's at the same level, or just slightly above where it was at the peak of COVID, when everyone got rid of everyone. So that tells you that jobs aren't in the marketplace at the minute. Sort of disposable income is not where it was. And again, if you look at it over the kind of the periods they're looking at, it's getting harder and harder and harder to get back to those good points.
Yeah.
So everyone's being squeezed everywhere at the minute. And it's gone, everyone's like, bollocks to this. I'm just going to try and look after my interests in what I do. And it's really, I think when you're looking at these issues when they come up, it's the bit where kind of trying to get to the bottom of actually what row you're having.
Yeah, that's absolutely what we're seeing. It's kind of any straightforward process seems to be subverted into these really complex, everything. When it's almost like a HR exam question where it's like, there's features of everything in this. There's every kind of process going on.
Yeah.
Like, and we can't do anything because we're playing chess and everything's a stalemate.
Completely, and the amount of times we've sat with people like going like, what is actually going on here?
Yeah.
Like, what row are we having? Because you're talking about that, you're talking about that, you're talking about that, and like we've been asked to do hear a grievance, and they've brought the kitchen sink to it, and I've said to sort of the companies that asked us to hear it, I said like I think there's two ways to approach this. There's we can talk about every issue that's gone on. Or we can have a conversation about getting this guy back into the workplace.
Yeah.
And it's like, that one, we can answer all the questions, but I don't think that's going to
It's not going to resolve anything.
No. Someone's going to be right.
Yeah.
And in reality, you're probably going to be right, and you're going to be right. You have different bits, but no one's going to win. No one's going to get to an outcome.
There's not a feeling of victory getting that letter outcome, being like, okay, here's a reasonable answer that responds to everything that I've raised, some of which do go in my favour, but some of which don't. But that's not... How does that resolve anything? How do we mediate? How do we get that person back in with that feeling of trust?
It's chaos. So, how are you?
All right. We've been busy always, but it's DSARs. Clients who have never had a DSAR have now had 6 or 7 this year, which is a huge shift for them. So we're trying to do a lot of upskilling because, my point on all of this is you shouldn't be paying a lawyer to do your DSAR, but you should be upskilling what you do so you know how to manage them strategically. So we're trying to do that piece with a few clients who are suffering in that ailment when it comes to just so many requests. But there's that, and then there's just litigation coming out of our ears, just so many tribunals. And it's all of these things. So we obviously at that stage sweep them up from the point where the resolution hasn't been found, they did not like the answer, and now it's all kind of, right, we'll see what a judge has to say about it.
But I suspect that probably a lot of the litigation you're seeing is that you saw a DSAR at some point in that process. Like, we're seeing that a lot now where...
It's almost standard.
Yeah, and it's... We've... Like, I as a friend have sort of advised a few people, and you would laughingly joke about the sort of the nuclear response to stuff, which is go off and sit with with stress, put a grievance in, bang a DSAR, and then just see where that gets you.
See what happens.
But that seems to be the playbook by everyone. No
matter what you're trying to do.
Yeah,
and it's almost like people are becoming... I mean, I'm obviously seeing the worst of it, but it's almost like people are becoming unmanageable, because if that's the playbook you're playing every time, not just your rogue, 1 in 10 sort of thing. Yeah. But
no, and I think it's interesting who's getting to that point as well, because I think to your point, it's not the rogue employees. Again, going back to my original job, there was a guy there, and his employee file was actually 3 files because the amount of grievances that he raised.
God.
And it was, you used to get one in pretty much every 2 weeks. And and part of the issue with that was like some of it, he did raise some valid points, but because of the amount of grievances he raised, it all got lost in sort of the volume of points being raised. But I think but we're not seeing those. It's not one individual just causing mayhem. You've got, rather than getting sort of 10 grievances from one person, you're getting a grievance from 10 people.
Yeah.
No, it's really kind of like, I think people look at the DSARs as well and think that it can be the fishing exercise, and it can be sort of the answer to a lot of ills. And I think I think there's going to come a point where kind of DSARs will go the way of sort of tribunal applications. They're going to have to realistically look at kind of how they manage that process.
Well, the reality is that there is no satisfactory answer, right? Because people are digging for the golden ticket, the bit of information, the silver bullet that's like, this is where you two had a secret conversation about me, and that's where you decided that X would happen, and it's all very unfair. But you either, if it doesn't exist, you can't provide it, and then that person thinks that something's being hidden from them, Or it might exist, but we're exempt from providing it, and that person thinks that their information has been mismanaged and not been processed according to the data obligations that you're subject to. Or you provide it and you're like, okay, we'll see you in court. You know, how do you win in that situation?
You don't. And I think your point is like people looking for the dirty dossier. And it is the thing they're going to have their moment of kind of like...
If I could do like a public service announcement for all data subjects, mine would be something along the lines of, honey, no one's talking about you as much as you think that they're talking about you.
No, and I do think there's points where people think they can stride in through the back of a tribunal as if they're in like Perry Mason or
holding
something.
their piece of paper being like, I've got it! I've got it!
I've sat there and going, yes! and it's like they can stride in and go, it is Professor Plum in the library with the candlestick.
And obviously, you have to remember, I mean, I deal with a lot of respondent work, and you have to remember, for claimants, it is their job, it is their livelihood. There is a huge personal, you know, it's their whole world in some respects.
Yeah.
I'm not talking about how much I love my job, but, you know, it's one of those things where it's a really big deal for them, so I can understand it's not out of malice that someone gets that whipped up in something when they genuinely believe that's what's happened, but that's what's really difficult to talk down in these processes.
Yeah, but I think that's the bit where people feel like but I think that's the whole thing in terms that we see is that when you talk to people, it's about the layering of a situation. So people go like, I did a really good process, and it's like, well, yeah, that's good. That's one part of it.
Yeah.
But it's all the other bits that go with it, and it's how you draw that bigger picture to someone to explain what you did, what you went through, how that came to life. And I think they think that kind of just having one thing just kind of covers all bases.
Yeah.
On that.
But also this kind of thing that what I've just thought about is, you know, feelings aren't facts. I feel like the grievance policies, we'll talk a bit about this with the ACAS Code of Practice that's just been brought out for consultation. But someone feels aggrieved, it doesn't matter to them whether the facts match up that they should feel aggrieved. The feeling of grievance is there.
Yeah. But again, this is a very explicit tactic that we take with people when we're going through grievances. But I think it's a very real thing to do, which is, if you go through a grievance, people will be understandably upset. And I say that we're going to separate these into two different things. Let's take kind of how you feel about it. We're not trying to diminish that. You feel how you feel.
Yeah.
But we can't use that as part of this discussion. So let's kind of stick that over there. So let's then look at the process of what's actually then gone on, and what's led to that sensation that you've got at the end of this, and why we sat here. And it's trying to use that to sort of, because part of the problem we see is like with the grievance bit, and just we're kind of going everywhere at this moment in time. But it's the people have a tendency to try and diminish people's feelings, and it's you shouldn't be reacting to the feelings. Yeah. But in the same breath, you shouldn't. We see a lot of employers turn around and go like, "Well, you're wrong for feeling that way," and it's like,
oh,
no, don't say that.
That's a really good resolution. Nice one.
But again, people don't know how to respond to it. And a much more sort of cute technique is to kind of go like, let's just kind of step over there. We're not going to get in debate about kind of why you feel the way, and if you feel that way, that's really bad. Sorry about that. Yeah. But let's look at what happened to get you there. And I think the more you can have conversations that way, the more helpful and useful it is in that space.
Well, I feel like we're still going to be dealing with these questions thick and fast from our respective clients.
Oh yeah, there's going to be more. But I also think that. But I think the follow on to that at the minute is. Just saying, sort of, we're busy at the minute. I think we've got probably an impending kind of short service dismissals that are coming, and as that sort of that reduction from 2 years to 6 months qualifying window comes in on the 1st of January, I'm really expecting probably September through to December, we're going to see a flurry of short service dismissals. And I think there's a few issues that are going to kind of catch people out in terms of notice periods. Yeah. I think there's a danger about not painting yourself into a corner on certain issues as well, like with the reasons, because one of the things that catches a few people out with short service dismissals is if they do put the sort of redundancy or kind of pseudo redundancy tag on a short service dismissal.
It's not you, it's me. It's not you, employee. It's us, business.
Cash flow is not great. We need to just make a few headcount savings, and you're in 2 years. That if you do that then if you then get to a point where you're doing 20 or more, and you're going to include your redundancies, and that if you get over 20 at that point, you're then into consultation.
So this is something people don't recognise, is that dismissals that are not by reason of the employee themselves, i.e. someone's conduct, someone's performance, count towards that figure. Magical 20 figure.
Yeah. And I think there's a real, I think because of where we're at in terms of, I think people want to get rid of deadwood. And I also think that kind of people are struggling.
Yeah.
And I think it'll be seen as this last real window to kind of, if you're looking at someone at the minute, you go, we'll get costs down. We've got, I'm not sure about these people. Do I want to be sat in a situation where I'm either settling with them or trying to take them through capability or go through a process after Christmas? I'd rather get rid of them before Christmas than after Christmas. And it's completely sounds so kind of cold and hard-faced. But I can see us having a number of conversations with clients about this. And I think in terms of sort of how kind of cold and hard-faced that conversation is, there is still people want to be nice about it, and they want to do things in the right way, and they want someone out of the business, but they don't want to sort of diminish that person.
But you've been talking about this, or I've been talking about this, as conscious uncouplings.
Yes.
Thanks, Gwenny P. But yeah, when it comes to that kind of, that Friends episode where it's Ross trying to unhug at night, and it's like the roll away, the hug and roll at like.
Vaguely. You see, I saw it the first time round.
But no, so it's one of those things where you're trying to, you can see where the writing's on the wall. You want to get there. You want to get there in the least offensive way possible.
Yeah.
You're not trying to destroy a person. It's just not working for whatever reason.
No, and I think if you are looking at the short service dismissals, you've got to be in that position where you say, right, you've got to be honest about performance. Don't get into the kind of don't do the sort of the conscious, the nice bit. I think the other bit as well is that you'd mentioned before we recorded that there's been an update in respect of the qualifying numbers. So in the past, it was a 3-month period, and if you had enough redundancies in that 3-month period, that you would then it would then trigger collective consultation. At that point.
So there's been the case of microfocus.
Yes.
And microfocus says it's a forward-looking 90-day period, not a retrospective one.
Yeah.
So, it's only about that. It's really difficult to kind of point to that point of crystallization, but it's the stage at which there will be 20 or more redundancies in the next 90 days, or dismissals which are not by reason of the employee.
Completely.
Then that's when you get that trigger.
So I think with people that are looking at the high volume short service dismissals, some people may go, right, we'll do it before Christmas to get the SSDs out of the way. Then after Christmas, we're going to announce another sort of restructure, because we'll then sort of then deal with the consequences in the new year, and we'll let people get Christmas out of the way. If you know you're going to do that restructure in the new year, when you're doing those short service dismissals in December, you're going to go past that threshold, and you're using all sort of the right or wrong reasons in that space. You then have a collective consultation obligation at that point.
And your HR1.
Yes. And you do need to submit the HR1, and they are hot on making sure you submit.
Have you done one since it's moved online?
No.
Right, top tip. You can't save your form and come back to it. You have to do it all in one sitting. And when you submit it, you can't then go and look at it. So print it before you submit it.
Okay.
There you go.
That's really quite helpful.
Hot tip.
Yeah. No,
it's one of those where I think we're also still waiting on the threshold to come in through the Employment Rights Act 2025. So this was that, look, it's 20 or more at one establishment in 90 days, or some other threshold which has not been determined whatsoever. Now, the proposals, the consultation results haven't come out yet, but the proposals were between 250 and 1,000 redundancies at an employer as a whole, rather than at one establishment, or they're playing around with it being a percentage of the size of an organisation, but the government's recognised that effectively, if you set that threshold too low, your big employers will just constantly be in a state of collective consultation, which is just not feasible. So they're trying to work out what that balance looks like at the minute.
But I think if they cannot find that balance, I'll be very impressed at that, because I think that's a bugger's muddle. To be fair. Talking of bugger's muddle, should we talk about the new ACAS code of practice that's been proposed? So not here just yet.
No.
So draft new code of practice.
Subject to consultation through to the end of September.
Which I suspect isn't going to be. I can't imagine that's changing too much, based on what I've read of it so far. Because I've not actually read. I've read some very good summaries of it, and it's
as is the way.
Yeah, excellent. And it's. I think this is pretty chunky in terms of. It's the first refresh since 2009.
Yeah.
And I think it's coming at the right time, and it's what we expected. Part of it is kind of standard, or kind of formulating, standardising. It's basically just confirming what we already do at the minute. But I think there's some interesting points in that, in terms of it's putting more obligations back on employers to deal with things. So like the first thing that jumps out is about the informal resolutions.
Yeah.
So informal resolutions. So obligation on employers to take more steps to deal with things informally, certainly at grievance stage. I felt like you were going to say something there for a second.
Well, they've taken real efforts, haven't they? They've relabelled it as concerns. They're not trying to go as far as, calling something a grievance that early on. And I think this is what what we were talking about earlier. People are so entrenched by this point, and they like to throw around the ACAS code of practice like it's a stick to beat you with.
Yep.
And it's a little bit, I think ACAS is saying, that doesn't work. If you've got that far, your grievance is entrenched, there isn't a resolution at that point, this needs to be brought forward earlier into that dispute.
Yeah, and I think there's two things that go on. So I think there's the people being aware of what it is, and then taking steps to do it and deal with it and get on top of it. I think the other thing is that I need to think this through my own head a little bit more, is that we often encourage people. So where you start to get concerns coming through, and though people kind of like wave stuff at you and go like, "Ooh, I've got this issue." We'll often say to people, like, lean into a grievance process. Actually, because if you start taking a formal process, and you give people a response, it's what you take away from that person is they've either got to address it, and you put the ball back in their court with that. So if they get a response, and it might be that it's a mixed bag or it's it's in your favour, that person's either then got to move on from it and make a decision at that point, or they draw a line on things and hopefully move forward. But at the moment you leave it unresolved, it just becomes this to your point, a stick to beat you with. But we've tended to opt to go quite formal quite quickly with that. But I think it's having all these aggregation of informal grievances that I think is going to blow people's minds. I think with everything that's going on with all the administration of just having people at the minute, people will like I can't be arsed with having another conversation with another person who's got another complaint. They can go and take a long walk off a shop here. In my view, not my view, but in their
well, it's hard, isn't it? We've talked about before. You're running a business, and the cost, the time, and expense of dealing with these issues isn't, something that is necessarily in your business plan to be like, I'm just going to carve out X percentage of time for dealing with these sorts of problems. So it is something that takes you out of what your business aim is, what your role is, what you're trying to work towards. Finding ways to make that more effective is going to be key. But I think something you're really good at is talking about, you've done a grievance, you've investigated, you found your findings. Not a lot of people then think about, what do we do now? How do we get this person back to work? How do we fix that relationship where there is clearly, whether someone's right or someone's wrong, there is a breakdown between the two, And I think that's something that we're probably going to need to see through. I mean, it's not part of the ACAS code, but this is something that a lot of employers are missing the trick on.
Yeah, but I think that comes with so as part of they are saying that if you don't do the informal bit, 25% uplift for failure on process. Now, there's an interesting bit in this in terms of with senior hires or people that are on bigger wages, where if they're looking to get out of the business with a package and things are a bit tense anyway to begin with, which you'd expect at that level, they then start to make sort of overtures of grievance and sort of things aren't working great at this moment in time. There's maybe some interest, there's a greyness to certain elements which aren't necessarily whistleblowing, but would be classed as serious concerns in what you do. I think there's some manoeuvres from people to sort of get into that process. Wait for people to get frustrated because at a senior level you shouldn't be dealing with it, and people don't want to be getting into grievances at that level. I think that emphasis on reconciliation of relationship and use that informal stage about how do we get things back on track rather than a informal, let's go through your grievance.
We're just calling it informal, but we're going to do everything we would do under formal.
And I think there's a couple of things. I think it's I think you've got to take the positive approach to, as I said earlier, kind of like we can have a conversation about all the points and we can give you a list of responses, or we can actually give you a
path forward.
Yeah.
So one of the other things they've got in this kind of proposed code, a carve out for small businesses. So they're saying, look, we understand that some people can't deal with this in the way that it is, and so that's quite refreshing to see. I would love to see the definition of a small business. Yep. In this, I'd also love to see how that can possibly be factored in. I mean, this is entirely judged by the judiciary, right? This is, this applies at the point where there has been a claim. You are in court. It's at the end, and something like that needs to be. How, as a small business, do you know that you're measuring against that successfully? When you do not know whether you count or what that means.
But I always felt like Polkey was a carve out for small businesses in the disciplinary process. Yeah. To a degree, not an explicit one, and it was the bit where it's like, as long as you kind of broadly got a kind of a reasonable process and the outcome was right and you could demonstrate certain things, but still kind of people still fall foul of it.
Yeah. So Polkey, just making sure that anyone listening is actually on the same page of us before we just witter down things, is the case that says if the only thing that went wrong was an unfair process, then it might technically be an unfair dismissal, but you'll only be awarded for how long it would have taken to do a fair process.
Yes.
So like 2 weeks for a fair redundancy if it's a small group or etc. So.
And I think with Polkey it was, in certainly my view of the world, it was to protect smaller businesses, because you might have the resources of the people around you to actually make a good informed decision. Yeah. But it's kind of if it was right fundamentally. But yeah, and I think it's the other thing. I think although we've got the carve out for small businesses, I think there is still an expectation, especially with the sort of the wave sort of traffic at the minute, is that there's still going to be some key standards within that which you're going to have to observe. So it's like manager training. They're talking about doing you've got to train your managers on this. No, I think I don't think they'll look too hard at this, but I think they will look at situations and go, how much of a mess is your process, and what have you done with your manager to support them in understanding what that process is. Yeah. And I think there's two parts to that. I think there's a training process. There's a training process when a manager comes in, which goes like, this is all your disciplinary grievances, flexible working.
This is how we do it. Get on board.
But I also think at the front end of it, you could be giving managers, as part of a investigation disciplinary pack, when that's managed, a manager has to have this is what you should do. I think it's going to go to real sort of Janet and John levels.
What do you mean?
Like, you know Janet and John books?
No.
There are times I just show my age. You know what I mean?
It makes me feel young.
You just make me feel really sad.
I know, it's what I'm here for. But no.
Thanks.
You're welcome. So, yeah, what is in something that's really going to spell it out for you?
Yeah, absolutely. Yeah,
Okay.
it's got to be like the Ladybird book to do in a disciplinary.
Okay, right. I get that reference.
There we go.
Thank you.
There we go. Yeah. But I think you are going to have to give people things like that, because if they don't, it's going to be just that. I think you're opening yourself up, in absolute truth.
So one of the other things that's come out in this draft code, there's no mention of how to have these meetings in terms of, look, post-COVID, lots of these meetings are happening online. What do you think about that? Are you suggesting that people can use a remote meeting for these kind of serious processes?
Depends. I think it depends on what the issue you're dealing with.
Are you a lawyer? That's such a lawyer's answer.
I've spent so much time on you lot. So I think we'd encourage face-to-face where we can. But I think because there's a couple of issues. One, a lot of people, because they are more remote, don't want to come in. They're happy for it to take place remotely. I also have a view that kind of it allows them to record meetings far more easily that way. So you've got to assume you are being recorded.
Spot the cynic. Yes. Experience has taught us.
I've been presented with a few too many recorders going, at that point. I think you've got to look at the status of the person. I also think it's about the kind of, once you do the meeting, it's the what happens next.
Yeah.
I also think it's about how you, like we talk about how you want people to think, feel and do in a situation as well. So I think with the more serious stuff, I think the more you can do it face to face, the more it has impact. And it's also things like, there's what you do, there's having the formal meeting, and there's what you do after the formal meeting with that. I'm not saying that you have a settlement discussion, but you can have a grievance to a disciplinary, a grievance or a disciplinary, and there's that conversation. You kind of shut the book, and then there's right. How do we move forward from this?
Yeah.
Which I think you don't have that impact when you're on a 2D image.
No, and when you're on a 2D image, but you're looking at yourself.
Or if it's me, you minimise myself, because it's you sit there and go like, "Here's a big eye." No, but I think. But again, I think it's with the code as it is, and with the code as it will be.
Yeah.
It's all about processing these things. It's not about impact. It's not about how you actually, because all this is a process to hang off what you do.
Yeah, I think we have debates on this, because when someone won't come to an in-person meeting, I would always rather give the option of a remote so that you can keep that momentum behind the processes, i.e. I'm not saying bend to every person who puts a ransom demand over a process, but moving forward is the best option in all circumstances rather than stagnating. But I have had judges go mad in tribunal about dismissal decisions being communicated through Teams or not in person. But, so I think in person is always my preference. And it's, even the tribunal is saying now, we don't get the same credibility of witness when we do things remotely. So I think there's almost, I would prefer that you tried to do in person, and if you couldn't, you do remote.
But I think there's the time poor nature of people, and going back to the 2008-2009 crash, I think people are doing more within their job. So saying to someone, you've got to travel down to Birmingham to do
100%. Very much, so many factors take into account for it.
The other thing as well is that where you get people that don't want to come in is having a conversation to say to people, because I think people fall into that, either you would have come to my office to come and see me to do your own disciplinary outcome meeting, or you've got to we'll do it online.
Yeah.
Whereas actually we try and encourage people to either neutral venue or go down to people. Yeah. And I think there's the tribunal piece, but I also think there's a bit where if you're dealing with, not that someone's going to like you for dismissing them, but I think there's a respect from actually kind of fronting up as well. So I think if you go and have the conversation, explain the decision, and go, this is why we've done it, I'm not expecting you to like me for doing this, but this is the information that I had and why I feel the way I feel about this.
It's much better than just getting a letter out of the blue by email.
Yeah, and I think that's a driver of some of the issues that we're seeing, is that there's a remoteness to some of the decisions, so people are more incensed.
Yeah.
And that's why we're getting people going up like a flipping rocket at that point. And not that I'm going like you should try and go like give someone a warm hug as you do it.
Yeah.
But I think there's an empathetic honesty to sort of say, I think you did what you did. I don't think you did it through ill will. If
you can stand behind that decision, you should be able to explain it to that person face to face. Like, whether even just a phone call to explain it would be better than when you just get a letter. There's no opportunity to discuss.
Yeah.
But and I say a lot with my clients that sometimes it's not a legal question about whether the thing you're doing is right or wrong. The thing that makes someone mad enough to bring a tribunal claim can be the little things like that. Like, how do you talk that person off the ledge?
Completely. But I think that's the thing with the new code of practice, that it's about that request to dig deeper. And I think it's digging deeper in investigations. I think it's digging deeper through the disciplinary process.
Yeah.
And it's being shown to be more thorough, or showing that you're more thorough in what you do. Because I presume part of their issue is that the stuff they're seeing is paper thin. Yeah. And that's it, and it's just not working.
The other thing I see a lot of, and I don't know if this is something that you've seen before, is I've got managers who feel like they want their day to bring that person in person.
Yes.
When they shouldn't. Yes. Maybe there's a sickness element to it. Maybe there is for whatever reason, the person doesn't want to come in and the manager's like, well, you're going to come in.
Yes.
And I see that a lot. And this is something I speak to quite a few clients about, where it's like, how do we help these managers see that I understand they're trying to manage, I understand they're trying to be active and say, no, I want you in and you need to jump to my tune. And I don't like... There's a degree of flex you can have in a process, but you shouldn't bend so much that the employee is the one dictating how everything should go.
No, and I think there's everything's a fine balance within it. So to your point, we see a few people that they haven't necessarily got the confidence to deal with the situation earlier on. So when you finally get them, either through a disciplinary or settlement agreements are worse for us.
Yeah.
Where someone's nearly out the door, and then you can see himself in the back of the room going, "Oh, bloody hate you!" And you just like,
did not need that parting shot.
Yeah. And you just like sat there ahead of the hands and just like, "What did you do that for?"
Yeah.
And it's an element of that, and I think we've got to be. But I think this comes around to a lot of the things in terms of everything. This seems less kind of staged. You've got a warning, then you've got a final written warning, then we look at dismissal. There's not that sequence to things.
Yeah.
It seems to go from 0 to 100 miles an hour very, very quickly.
Yeah, absolutely.
And I think this is the big part of that. I think it's they can see that within the tribunals that people have got performance issues and they're not being dealt with. And then as soon as sort of someone does something wrong, it's being jumped on at that point and gone like
100%.
And I think I think this is what it's driving towards, is to get away from that. I think the suspension one's an interesting one. So
in the code where they're talking about, look, you should only really suspend when there's actually going to be a riskier investigation.
Yeah. But to a degree, sort of I come from the school of people used to get criticised if they didn't suspend.
Yeah.
Where if this person was a legitimate threat to your business, why would you keep them in the premises?
Yeah.
Whereas actually they seem to be saying the opposite now, in terms of unless there's a direct impact to the investigation itself, or say you've got someone who's like going to seriously kind of damage the business.
Yeah.
You've got more latitude to keep that person in the business at that point, which I think is better and worse in the same breath. I do think suspensions are something people reach for a lot of the time in situations where
that direct risk element isn't there, right? Like, so, you know, maybe there's been a dispute about name calling or something like that in the business, when it's like, you can't really say that someone's going to create such a huge amount of damage by remaining in the business doing the same thing, if that's the risk. I mean, how are we quantifying this? Are we saying that there's a risk of that person doing more of the same thing they're being disciplined for? Or are we saying, okay, actually, we think this is going to escalate and someone's going to do something, you know, like go up to their witnesses and say, oi.
Watch out. What, like I did to you this morning?
Like you did to me this morning. I'm still grumpy about it.
I know you are.
It's interesting because I think when it comes to suspension, I think it gets used more by employers who are trying to buy themselves time to do their investigation without, like, and they're almost preserving things in the place where the disciplinary left off, as in like the investigation, giving space to the investigation to conclude itself, but using that almost too liberally to take a couple of weeks to do it. Yeah. When they shouldn't, depending on the circumstances.
Yeah. But. And I think granted, like I remember the good old days where we'd have people on suspension for like multiple months. And like I remember joining one business that I think somebody had been on suspension for a year. I think it's more to do with the size of client that we have, but we see that very infrequently these days, because people really want to get it done, dusted, out of the way, all dealt with. But I think we do see that where kind of you can see people get lost in the process, and then because they're out of the way, it becomes the least. Well, it's not the headache they've got to deal with immediately. Yeah. At that point. And I think that's where that's where it's been misused. Not misused.
It's been a tool that people have leaned on more heavily that might not be able to be leaned on in that way if this code comes through. And when we talk about this, I mean, look, this code comes out and all it changes tangibly. Yes, people will design their grievance processes, disciplinary processes around it, using this like a wand. But it will realistically only have an impact when it comes to tribunal awards being uplifted by 25%. So there is a play to make here about still using suspension in a way that suits you. But if your employees know that you shouldn't be using it that way, then you also give rise to potential risk of things like someone saying this is a victimisation. So what we see is suspension, not only, you know, you have your own guidance you have to sit by and you have to comply with it according to that guidance because of the potential uplift, etc. But also people using it as its own claim. We've had one on our desks this week of an employee saying, well, you suspended me for X, but you suspended him. You didn't suspend him for the same thing.
But I think you can see the process slightly changing at the minute. And one thing that Tom, who works with me, one of the things that he's noticed sort of in his reading is that there's been a bit of a push towards invite to investigations. And he's raised the question, should we be, so previously you would just pull people in because that was your right when it's fresh in people's minds. And he's seen more and more sort of tribunals where people are getting criticised for just pulling people in that way. And additionally, they should have invites, should know what they're going in for. And the other thing I think with the non-visible disability point is that if you're not aware of kind of what disability someone's got, it's are you then sort of discriminating?
This is all over my desk. This is like hundreds of cases I'm seeing of this where people are saying, okay, yeah, maybe I did do the thing you disciplined me for, but when you investigated me, I actually have this impairment that means that I couldn't explain myself properly and I couldn't advocate for myself or understand what you were asking me because I was taken so back. And it's really hard to answer that.
But I also think I think sort of the crib sheet for managers in the meeting, I think this is where the crib sheet is quite useful.
100%.
Because I think to a degree you can still do the investigations, but it's this is what you've got to do. So you've got to be really explicit about what it's about. I think you've got to say to someone, do you need any adjustments for the meeting as you start, or at least give them like 5-10 minutes to think about kind of what they need, and step out the room. Unless they go, no, I'm absolutely fine, and even then, they might go back and go, well, I felt under pressure. But I also think there's once you've been through it once, taking that initial statement to then go back through it again.
100%.
To then make sure this is all correct.
So this is the key for me, is that there is still a benefit, and I don't mean investigation by ambush, but being able to pull someone in before they've had a chance to rehearse answers or necessarily understand that they, that you don't want someone spending too much time thinking over.
But
designing a response, but giving them a second bite at it to say, right, we're going to have an initial chat about this, high level.
Yeah.
And I just want to understand what's going on here. And then coming back to them and saying, right, you've had some time to understand now.
Yes. But then that comes back to so if you take HSC do that in a pretty similar way. And I probably start to use their language, because their whole point was, it's when it's fresh in someone's mind.
Yeah.
Which actually, for an investigation, if you've had a big tear up in somewhere and it's all got a bit nasty, you do want things.
It's vital.
Yeah. But I think it's that, let's go back, and I think it's where it's key individuals. It's not everyone.
Yeah.
And I think this is the bit where people will go, and if I've got 8 witnesses involved in this, do I need to go back and speak to all 8 people? No, you don't. It's the key people in that situation. Yeah. So it's probably the 2 antagonists that you've got in that situation. They're the people you take the main statements off, and then you come back to those individuals and go, just walk us through this.
Yeah.
And you just wrap it up that way. I think that's our subtle change to the process.
Yeah.
I think anything more than that is overkill.
So one of the things the code talks about on that line is it's actually explicitly talking about making reasonable adjustments in the process. So, being able to factor into your investigation or any part of a grievance or disciplinary. We're seeing so many more claims now about processing issues, not being able to advocate for yourself, not being able to answer on the spot. And that's something that, like you say, that crib sheet, that design process should really accommodate.
But one of the things we're doing, certainly a lot of grievances, disciplinaries that we're doing now, is that we're asking people if they need any reasonable adjustments ahead of the meeting.
Yeah.
Because it's what you don't want to it's not even walking into the meeting, it's when it comes down in the appeal or with the ET1.
Surprise!
It's like, I have this issue. So the more that you could, and some people really do take against it as a line when we put it in there. And it's seen as being sort of soft, but actually it's quite critical in respect to the fact that you're giving people a way to then flag something.
You flesh it out in the process, and then you can use your process to address it, build it into how you make your decision.
Yeah, and I think again, with the code of practice, it's not going to be a major significant change. I think it's hardening up some of the things that are probably out there at the minute. I think I'm really kind of hesitant. Hesitant's the wrong word. I'm excited to see what the small business carve out looks like and how that's going to be. Yeah.
But the one thing that's missing, no mention of AI.
True.
So the code of practice does not say, this is you shouldn't be using AI this way, but it does say try and do something shorter employee when you bring something so that it can be understood.
And it puts obligation back on the employee to say you've got to be more succinct. You've got to be able to succinctly kind of describe what you're doing.
Yeah.
No, again with that, sorry, you were pointing on point now, but it's enforcing that.
Yeah.
So if you
is there a word limit?
It's okay. You've got one side of A4.
Yeah.
And you
Times New Roman, size 12.
There's someone doing it in 6. And that they've extended all the borders as well. But that I think there's what it aspires to do, and I think what it ends up doing.
Yeah.
I'm the cynic in me. Don't know what's up with this morning. Probably a long day yesterday, but it's that I don't think we'll kind of get that enforceability that we're looking for. I think you will do on odd occasions, but it's going to be really bad.
I think you're going to have to design your own way of dealing with it, right? So the difficulty is that you can receive an AI-generated grievance that's 44 pages, and you can sit and have the conversation with someone and say, look, we've received all that, but what is it that's going on? And you can scope. But if there is a golden nugget in that 44 pages that genuinely points to something, so let's say for example, there is a really serious allegation of whistleblowing somewhere bedded in that, but when you sit down with the employee and they're trying to distill their 44 pages into what I'm mad about that they don't quite get to, you're still on the hook for being on notice of it. You can't just say, well, we're not reading the 44 pages. So, there is probably a point to put in your policies, to put in your framework, and deal with your managers to say, holding out to employees, being like, the more you write to us, the more we might lose the points that you need us to focus on.
Yeah.
But that doesn't get you out of having to just go through it and make sure.
Yes.
It's a hard place to be in.
It's great fun though, isn't it?
I don't know. I've got some upcoming preliminary hearings. So, like, obviously, AI coming in sort of the last 2 years and really being used in the last year, I'd say, when it came to grievances. Yeah. We're now at the stage where those preliminary hearings are now getting in front of judges, and you can just hear the judge be like, right, what are you on about? So I've got a good few up this month that I'm... preliminary hearings are going to go from being a half an hour case management appointment to a 3 hour, right, what did you mean when you said this at paragraph 47?
That's interesting. That's
It's not interesting for anyone other than me. It's just feeling really sorry.
No, that's I do, because that reaction's gonna set the tone for everything else.
Yeah. So, happy days.
Maybe just maybe.
Right.
So, marvellous. On that happy note.
On that joyful note. So just feel sorry for me when I'm sat there for my 3 hours.
Don't worry, I won't the slightest.
But, like I say, they've gone through something. I'm just doing my job.
Just happily as well. So, like I said, thank you for your time once again. We're going to be back probably early September, because I've got to apparently parent my own children.
Oh, shame that.
I know. So I'm off to do that, and then we'll be back sort of early September. We'll get back, and then you'll be hopefully at your preliminary hearing with. Is that going to be in the next couple of weeks?
Yeah. So I might still be in it by the time we start recording again. Might have to send somebody else.
You do love court as well, to be fair.
I do.
You do. Weirdo. So if you've got any questions, if anything that you need help with, don't hesitate to get in contact. You can contact me at alastair@ezhr.uk, and that's Alastair's ALA rather than ALI, as most people tend to spell it these days. Love it.
And you can find me on the Horsfield Menzies website under Rachel Rigg.
Excellent. Thank you once again, and we'll see you soon. All the best. Bye.
See you soon.
You're joking. Not another one?